Hello everyone, welcome to Aspirants World. Today we are going to see the Digital Personal Data Protection Bill. What are its key features, how significant it is to introduce, and what are the challenges after introduction of this bill. So all these details we are going to see in this video. So let's start. The Digital Protection Bill 2022, which pertains to data protection and the regulation, has recently been made available for public input. If we see, the bill is expected in Parliament during the monsoon session 2023. The Digital Personal Data Protection Bill 2022 holds significant importance as a fundamental component of the comprehensive structure of technology regulations being developed by the center. However, it is important to analyze whether the Digital Personal Data Protection Bill acknowledges the importance of safeguarding an individual personal data rights, even as it addresses the necessity of processing personal data for legitimate objects. At present, India lacks a comprehensive legislation specifically addressing the issue of data protection. The regulation of personal data usage falls under the purview of the Information Act of 2000. It falls under Information Act of 2000. The insufficiency of this framework in safeguarding personal data has been duly noted. In the year 2017 itself, the central government established a committee of experts on data protection, which was led by the B.N. Sri Krishna. The primary objective of this committee was to investigate and analyze matters pertaining to data protection within the country. The report was submitted by the committee in July 2018. After submission of the report, the Personal Data Protection Bill 2019 was introduced in Lok Sabha. But the bill underwent referral to Joint Parliamentary Committee, which subsequently presented its report in 2021. The bill was withdrawn from Parliament in August 2022. The draft Digital Personal Data Protection Bill 2022 was made publicly available by the Ministry of Electronics and Information Technology in November 2022 with the intention of soliciting feedback from the general public. The Digital Personal Data Protection Bill 2022, which was initially proposed in November, is anticipated to be presented during the monsoon session of Parliament, which is commencing on July 20. So, after the Cabinet has given the approval to the draft bill on July 5th, now it is expected the bill is going to be lie on the table of the Parliament in this monsoon session. With this importance and with this introduction, let's see what are the highlights of this bill. And before we see what are the highlights, let's understand what are the key features of this bill. This bill contains the two major provisions. One is data principle, another is data fiduciary. The data principle refers to the individuals whose data is being collected, which is very, very important. The data principle refers to the individual whose data is being collected, and if it is a minor child, that is the children less than 18 years, their parents and the lawful guardians will be considered as their data principals. The data fiduciary is the entity or any individual, company, firm or state which decide the purpose and means of the processing of an individual's personal data. So this bill speaks about both the data principle and the data fiduciary. If we look at the highlights of the bill speaks about the personal data may be processed only for a lawful purpose, which is very important. If you are processing anyone's personal data, it must be for the lawful purpose for which an individual has given the consent. The data fiduciaries will be obligated to maintain the accuracy of data, keep data secure, and delete the data once its purpose has been met. So this is what the action the data fiduciaries has to take for the protection of the data. The bill grants certain rights to individuals, including right to obtain information, seek correction and erase and grievance redressal. The central government may exempt government agencies from the application of the provision of the bill in the interest of specified grounds such as security of the state, the public order, and the prevention of the offences. The central government will establish the Data Protection Board of India to adjudicate the non-compliance with the provision of the bill. So in this way, the bill contains all the provisions regarding the lawful collection of information, the usage of information only for the legal purpose, and the accuracy of data maintenance, the security of data, the redressal grievances, and along with that the maintenance of the data protection board. So these all are the major highlights of the bill. And if we see what are the features of this bill, the notice and consent is one of the important thing. The notice and consent, it contemplates seeking the prior consent of the data principal or the individual whose data is being collected, which should disclose the description of personal data sought and the purpose of processing it. So it is very important to get that prior consent. And the next key feature is obligations of the data fiduciary. The data fiduciary has the obligation to ensure that personal data is processed, stored, or erased in a safe and proper manner. Bill imposes some responsibilities also, like if there is a breach, the data fiduciary must inform the board and the data principal. Deletion of personal data once proposed for collection is no longer served, or the retention is also no longer necessary. So every data fiduciary must appoint a data protection officer to address the data principal's queries and the concerns. Along with that, there are additional obligations also while processing personal data of children, which includes the seeking consent from the parents and the guardians. So they have to take care of all these issues. Regarding the deletion of personal data also, once the purpose of the collection of data is over, the data must be deleted. The significant data fiduciary, it speaks about the central government can identify a data fiduciary as a significant data fiduciary if it handles the high volume of sensitive personal data. If any agency is maintaining very high volume of sensitive of data, then it is considered as significant data fiduciary. It involves a risk of harm to data principal and impact on the sovereignty and integrity of India, and it even threat the security of the state and the public order. So they must appoint an independent data auditor and conduct a data protection impact assessment, and periodic audit must be done to ensure that compliance. Along with that, the bill also mentioned the duties and rights of data principal. Bill stipulate duties of the data principal to the extent that it is not registering a false grievance or complaint, not providing false or misleading information, or even suppressing information while the data principal disclose such information. So it is the responsibility of the data principal also to provide the right and accurate data to the data fiduciary. And the establishment of data protection board is one of the important content under this. Along with that, the penalties also can be imposed by a board. Suppose if the bill proposes the 6 types of penalties which extend to a maximum penalty of up to 500 crore also. So the penalties imposed by the board is, maybe very harsh, and this bill gives such type of power to this board also. The transfer of data outside of India can be done if it suggests that it will notify a list of countries to whom a data fiduciary may transfer personal data in accordance with such terms and conditions as may be specified in the bill. Based on that only, the transfer of data can be permitted under this bill. So it is majorly talking about how the protection of the personal data of an individual can be, secured in the country. So moving, of course, this bill has certain limitations. First and foremost hurdle it has is it conflicts with the RTA Act. We all have the awareness about the RTA Act. The bill is criticized for seeking to dilute the provision of the RTA Act, which has empowered the citizens to access information and holds the government accountable. The RTA Act includes a provision to protect the privacy through Section 81J. In order to invoke this section to deny personal information, at least one of the following grounds has to be proven. The first one is the information sought has no relation to any public activity or public interest, or is such that it would cause unwarranted invasion of privacy, and the public information officer is satisfied that there is no larger public interest that justifies that disclosure. So the proposed bill seeks to amend this section to expand its purview and exempt all personal information from the arbiter of RTI Act. So this is against to the RTI because the bill may limit the right to information to be published in near future. Along with that, it has even the conflict with the right to privacy also. By empowering the executive to draft rules on a range of issues, the proposed bill creates wide discretionary powers for central government and thus fail to safeguard people's right to privacy. Along with that, the no autonomy for the Data Protection Board, as the bill has given the establishment of Data Protection Board, but the bill does not ensure autonomy of this board. The institution is responsible for the enforcement of the provision of law. Given that government is the biggest data repository, it was imperative that the oversight body set up under the law be adequately independent to act on violation of the law by the government entities. So this is also one of the limitations we observe in the bill. Along with that, the digital by design, which speaks that the bill stipulates the Data Protection Board shall be digital by design, including receipt and the disposal of complaint. As per the latest National Family Health Survey, only 33% of women in India have ever used the internet. The bill therefore effectively fails millions of people who don't have meaningful access to the internet. So, this is all some of the limitations of the bill. Whatever, the Supreme Court of India in the Justice K.S. Puttaswamy judgment has established the constitutional principle of the data protection law, thereby reaffirming the fundamental right to privacy. Justice D.Y. Chandrachud asserted that the establishment of such a system necessitates a meticulous and delicate equilibrium between the interests of individuals and the valid apprehensions of the state. So now it is a challenge now it is a challenge for the government to maintain that fair balance between the security of the data and giving of the privacy to the individuals. So let's see how this bill can be shaped out in the implementation. Hope you guys has understand the data protection bill. So this is all about the video. Do like, comment and share our video. Subscribe our channel for further notifications. Thank you very much, guys. Have a great day. See you in the next video.